start. We'll start in like 2-3 more minutes. I'll just wait for some other people to join, and after that, we'll start. All right. Okay. Okay. All right. We'll start with today's session. So before we begin, I am Shinjini. I'm actually so can everybody hear me? You can just give me like a little thumbs up on the chat so that I understand that you guys are there with me right now. Great. So my name is Shinjini, and I am a teaching assistant to Professor Nigam. I'm an academic fellow at NLS Bangalore. I teach, I research, and I assist Professor Nigam in his taxation course for PACE as well as for the on-campus courses for BLLB, for LLBs, and yes, so that is what I'm doing right now. And for pace, I will be taking a few classes like today's, and probably the income from other sources, bits and pieces of tax avoidance and international taxation. And today we will be starting with something called the concept of salary. So, till the last time, Professor Nigam had given you an overview of the tax system, how the Indian tax works, what the act entails, the different heads of income, as well as the schedular nature of the Income Tax Act. And that introduction had led you to also understand what the concept of income is. And you had gone through different types of cases like um, I think Sharky was one of the cases that you had studied, Kiki Bai, then Bhagwan Das, as well as I'm guessing you had gone through Subhash Carboni and all the carbon credits and how it works, and which had given you an overview of what exactly is income, what exactly is income realized, and when would the tax authorities charge or make an income taxable, and how they would make an income taxable. So through the heads of income, we had seen that there are different types of heads of income that are taxable, like income from house property, income from other sources, salary is one of them, business income, and today we'll do salaries on the heads of income. We'll start with salaries. So before we begin with salaries, I would give you a disclaimer that all the sections that I mentioned, all the provisions, regulations that I've been mentioning, will be mentioning in the next 2 hours, will be all related to the Income Tax Act 1961. I will not be referring to anything in the new legislation. Um, and only if required, I will let you know in places where you may have to reference it. But for salaries, at least for this session, we will not be referencing any section from the new Income Tax Act, which will be in place probably in the next year in 2026. So everything will be done from the Income Tax Act 1961, right? So what are we doing today? Today, we will begin with getting an overview of what exactly is salary, what parts of salary would be taxable, and how it will be taxable. Then we will go on to different types of sections on the Income Tax Act. Section 224 to subclause 24, which defines the types of salaries, allowances, and prerequisites which would be taxable. Secondly, we will look at section 15, 16, and 17. These are the major sections of salary income. Then we'll look at a few cases which are important to understand how um, how the courts have interpreted the words salary, allowances, prerequisites, profits in lieu of salary, and then going on to ending the session with a few probably questions from my side towards you, so that I understand that you have had a basic understanding of what I've told you. And lastly, we'll also do a bit of business income. We'll start off with the concept of business income, which Professor Nigam will obviously take up, but we'll do a case called the Raj Dadarkar case, which is more inclined towards business income. But I just wanted to start off with it so that Professor Nigam can take it up in the next class. Okay, so let's start with the concept of salary. So firstly, as I mentioned, section 2 subclause 24, this defines income, any type of income, and within this section we also find the rubrics of what is allowances, what is prerequisites, and what could be chargeable or taxable as salaries under this particular section. So if you look at section 2 subclause 24, subclause 3, 3A, and 3B, these are the major three sections that actually give you an overview of what the Income Tax Act considers as to be taxable income, which is primarily salaries. Okay, let's look at 224. Income includes Subclause 3, the value of any prerequisite or profit in lieu of salary taxable under clause 2 and clause 3 of section 17. Section 17 is majorly the charging section for salaries. As we have discussed earlier in the first 2-3 sessions, is that every type of income that we come across has a charging section that makes it taxable. So here, for salaries to be made taxable, section 17 is your charging section, right? So here, under 224(3), it gives you two specific words: prerequisite and profit in lieu of salary. Now, profits in lieu of salary is something that we will discuss more broadly in the case of Karamchari Union versus Union of India, as well as in ITC case. Okay. Secondly, when we go to the next section, which is section 224(3)(a, it states that any special allowances or benefit other than prerequisite included under subclause 3 specifically granted to assessee to meet expensive wholly, necessarily, exclusively for the purpose of the duties of an office or employment of profit. Now, through this section, we can assert that any type of benefit that you're getting, a money prerequisite through your course of employment. So when you see for the performance of the duties of an office or employment of profit, this shows that under the course of your employment, if you're getting any type of gain, advantage, money, or non-monetary benefit, that would be included in the income or income from salary, right? Moving on to 224(3)(b. Okay. Any allowance granted to the assessee either to meet his personal expense at the place where the duties of his office or employment of profit are ordinarily performed by him, or at a place where he ordinarily resides, or to compensate him for the increased cost of living. Now, from this section, we have the concepts of what we call house rent allowances, city compensatory allowances, HRA, DA, probably other allowances, could be educational, could be anything. So any type of allowances that kind of helps an employee to relocate or to help him cope up with an increased cost of living that they get from their employers is also considered as to be a part of the income and would be an addition to your salaries or a part of your taxable income thus, right? So this is what is happening right here. Okay. Indulekha, I will share my screen at the end when I am just summarizing everything. I do have a PPT, but I just want you to go through the sections with me. And if you want, you can open the Income Tax Act as well, side by side, because I'm mentioning the sections. I'm not really going through in-depth reading of it, but also giving you an explanation of it. So just you can open the Income Tax Act with you. But at the end, I will anyway have a PPT that I'll share and I'll just sum up everything through the PPT. And I'll also post the PPT on the forum, so don't worry. Yes, so this is what section 2, subclause 24, subclause 3, 3A and B specifically tells about allowances, prerequisite, profits in lieu, and how these incomes are actually included in the salaries. Okay. Okay, now we will move on to the section, the major section that are sections 15, 16, and 17. These are the three sections that we will continuously look at through every cases and regulation. And these are the, as I said, section 17 is the charging section, while section 15 and 16 gives you a kind of analysis of what income would be taxable. Um, Rohil, I just said that I would share my screen a little later. I'm just going through the sections at the moment. Okay. So, yes, next we have section 15. Now, if you look at section 15, you will see that um, the section
Hello,
has basic three clauses. And
hello.
yes,
Just can you repeat once again? Because I'm just trying this.
I'm sorry, I can't hear you.
Can you just repeat what you have told me now? Because I can just now missed it.
Okay, your voice is coming, it's breaking a lot. Could you write your question down on the chat?
Now it's audible. Now it's
Yeah,
audible.
it's better now. It's better now.
Yeah. So just I want to tell you that just can you repeat the things which you are telling me because I have just missed that session. Means I've just joined just now only. So
Okay, so you want me to repeat the
yes,
sections.
yes, yes, yes.
Okay, you can just go through the recording later because I have three major
Okay,
cases
okay.
to do. You can just go at, I just started with section 2 subclause 24. It's majorly talks about allowances, prerequisite, and profits in lieu, and just I had just gone through them as what exactly they entail. So you can just go through them from the income tax act, just give it a read, or you can just go through the recordings later. Okay. Okay, so I was doing section 15, right? So when we talk about section 15 is a very small section that gives you the basics of due versus receipt. Okay, can anybody tell me what is due versus receipt basis that section 15 talks about? Or just give me an overview of whether you know what is when salary is due and when salary has been received. What is the difference? If anybody has an idea. Anybody? When is salary due and when is salary received?
Salary due is the means that the working period is over, and the receipt when the amount is credited in the account.
Okay. Anybody else? Anybody else who knows what is salary due and salary received? Okay. Um, as Atul said, though salary due is not necessarily what Atul is saying, but yes, salary received is right. Whenever salary has been credited to your account or you have gotten the monetary amount that was promised to you, that is when your salary has been received. So at the end of the month on the 30th or at the beginning of the month on the 1st or the 2nd, whenever your salary on your phone, it gets a ting and it shows that credited this much amount, that is when you've received your salary. What is salary due then? Salary due is when, for example, your employer states that um, your money for June 2025 would be given to you in probably August 2025. So your salary has been realized in June 2025. You are obligated to get the salary, but it is in arrears, or you will get it at a later date, right? Or due would also mean that you have already your salary has been accrued but you have not received it, so it's due, right? There is also salary paid in advance, which means that okay, June 2025 salary, you get it beforehand in May 2025, right? Sorry, June 2025 salary, you get it in May 2025. Okay, so this is due versus receipt. Due is when you have an arrear in your salary, you are liable to get it in the next few months. Received is basically you've received it in the month you are actually getting paid. So section 15 actually tells you when this type of an income would be chargeable to tax. So the first clause of, if you look at the first clause of 15.1, what does it mean? It specifically states that any salaries that are accrued or due, just as I mentioned, accrued or due, whether paid or not, but is actually realized. So you realized your income, you have done your job, and you are liable to get the income. So your income has been realized, but the salary is due to be paid at a probably later date. So it's unpaid right now. Okay. And as I mentioned, like example is that probably the employer does not pay in June 2025, but it will still be taxable for the year 2024 to 25, because obviously you have realized your income. Okay. Your second clause 15.2 basically talks about salary that is paid in advance. So for example, as I mentioned, the June 2025 salary has been paid in May 2025. It will be realized in that financial year itself. It won't be realized at the later at an earlier period. Okay. So for example, you received your salary, so just look at it from March 2024 to March 2025. Let's look at this period. So for example, you get your salary of um, April 2025, 2024 in um, okay, you get your salary for March 2025 and April 2024. So it will be actually taxed for the previous year, the year that you have received it. So you have realized it at an earlier period, you realize it. So the taxable income would be for that year itself. Okay. So this is clause 2 for salaries paid in advance. Now let's look at 15 clause 3. So 15 clause 3 talks about salary or arrears or past dues. So for example, you are supposed to get a particular salary and you have not realized it. You have realized it, but you are getting paid for it at a later date. So it would be taxable for that current year. As mentioned earlier, it would be taxable for that current year in the year that it was received, if it has not been paid early. So for example, as mentioned in clause 1, that your salary has been due, your income has been realized, but you don't physically get the monetary amount, but it will still be taxable for that year. But if you have not paid the tax for that amount in that year, you will have to pay tax at that later time when you actually get that salary. Okay, that is what section 15 clause subclause 3 actually states. Okay. For example, you are supposed to get a bonus in the year 2023. Okay. Your employer states that, okay, in the year 2023 you are supposed to get a Diwali bonus, but you don't get that Diwali bonus that year and you get it in 2025. So that income, if you have not paid the tax for the income realized in 2023, then you have to pay the income tax in 2025 when you actually get the salary. That is also there in section 15 subclause 3. Okay. Now moving on to section 16, it talks about, it's a very simple section, it's on TDS, specific deductions from tax by taxpayers, from taxpayers gross salary, that actually reduces the overall taxable income for that year. Okay. So any employer is liable to actually deduct a certain amount of TDS from your salaries, and that salary is non-taxable. Okay. Moving on to section 17. Now, 17 is the most controversial section because it is for salaries, because it is firstly the charging section, as I mentioned. Secondly, it has a lot of mentions of different types of words like prerequisite, allowances, profits in lieu, rent allowances, educational. So all this makes it a very confusing section as to what is actually chargeable to your salaries and what is not. Okay. So the problem arises is to understand different types of wordings that this section entails. Firstly, section 17 actually defines the term salary. Salary, what is salary? It is a basic payment of compensation to you from your employer. It comes from a course of employment or from a contract of employment. So you have to have a contract of employment with your employer. You have that contract of employment, and it is on the basis or it is on the privity of that contract that you receive a certain amount of compensation. This basic compensation is your salary, and it is chargeable to income tax. Obviously, there are different types of thresholds that each year the um, financial act comes into power, and they'll give you the threshold. And if you fall within that threshold, you'll have fall above that threshold, you'll have to pay taxes according to the slabs of income, right? Additionally, if a lot of government employees do get paid what we call allowances. Now, a lot of times, a lot of controversies have come up with the basis that whether such allowances are taxable, whether they are not taxable, because some of them are monetary and some of them are non-monetary. So are they taxable or not? Okay. So if you go through section 17, you will see a mention of different types of words like wages, fees, commission, annuity, gratuity. All these are taxable income. Okay. Um, we move on to understanding what different types of um, allowances, whether they would come under taxability or not. Okay. So the first case that we'll do is Karamchari Union versus Union of India. Okay. This is there in your note 13 of your reading material. So note 13 has three specific cases: Karamchari Union, ITC. These two are for your salary income that I'll be doing with you intensively. And this third case is Raj Dadarkar, which is not salary income, but it's business income. But I'll just start off with it so that Professor Nigam can continue on his next class. Okay. But anyway, till now, do you have any questions? I'll just give it a minute so that if anybody has any questions, I can just help you out. Anybody have any questions? Okay, section 15. All right. Section 15 has three um, three basic clauses. Okay. And these clauses specifically tell you about the timing of your salary, when it is due and when it is received. And if it's due, it will be still taxable. If it's received, it will still be taxable. But the due versus receipt is, this is what is due versus receipt. Receipt or received means that your salary has been credited to your account. You have gotten your money. That's it. Simple. What is due? Due is that today, whatever work I am doing, for example, this is the month of October. My employer tells me that, okay, you've worked for October, but unfortunately, we'll not be giving you the salary for this month. However, my income has been realized for this month, right? I have worked and I have realized my income, but I'll get the money at a future date, whatever, at December or probably the next year. So, for example, for October 2025, it will still be realized as an income for this financial year, this 2025 financial year. So I will have to pay tax on my salary for October 2025 in March 2026, which is my this financial year 2025 to 2026. Even if I get my salary for October 2025, probably in May 2026, after this financial year, just because I have worked and have realized my income, which is to be paid at a future date. Okay. Now, what is all salary paid in advance? Paid in advance is your second clause, which means that you for October 2025, I am working. However, I have got my salary for October 2025 probably in March 2025, right? So my salary would be chargeable to income tax for the previous year, not this year, previous year, 2024 to 2025, because this today's salary I've received it earlier. So since I've realized it earlier in March 2025, I will have to pay income tax in that year, right? Okay. Now the last portion that comes in play is that, okay, probably for the first example that I took, just remember the first example that I took is that October 2025. I am working. I have not uh, gotten paid even though my income has been realized, and I decide that I don't want to pay taxes unless and until I get the amount. So now I get the amount in May 2026. Now since I have not paid my taxes earlier, I will have to pay it in 2026 to 2027 financial year. Simple. So whenever your income, even though your income has been due, or even though have you received your income, whatever it lies, it will still be chargeable to income tax for that financial year. All right. This is what section 15 very uh, rudimentarily means. It's a very small section. If you go through it, you will understand it uh, in a very basic manner. So it's a small section. Okay. Anything else? Anything else that anybody wants to ask about the sections? I will go on to the cases right now then.
Ma'am, what are perquisites? What are perquisites?
We will discuss that right now through the cases. Don't worry. All right, then I'll move on to the cases. Okay. So the majority of the problem rise in the words, just as Vivek mentioned, prerequisites. One second. Um, whoever has opened the whiteboard, please. Thank you. I have a PPT, but I just want to let you go through all the cases and all the sections. And after that, when I summarize it, I will share my screen, show you the PPT, and we will go through everything again. Okay. Yes, Karamchari Union versus Union of India. Now, as Vivek mentioned about prerequisites, what are these words? Prerequisite, allowances, profits in lieu of salary. How do they play up in a salaried income person's account, and whether they are chargeable to income tax? Now, these words are basically prerequisites, allowances. These words are specifically meaning towards any type of advantage or benefit that our employer is giving you, any type of advantage or benefit. So a lot of times we see that government employees, a lot of private employees have the options of ESOPs, employment stock option plan. Does anybody know what an ESOP is? Anybody? ESOP?
So basically, ESOPs means so basically ESOPs means where a company provides a part of shares to the employee
Yes.
as a share.
Right, exactly. So It's a benefit, it's a prerequisite on top of the salary that the employees get. Now ESOPs is mostly to retain a certain amount of talent into the firm and not letting them go away. It's a benefit to the firm, it's benefit to the employees as well, both ways. But to the employees, it's an addition to their salaries, which is a prerequisite to the salaries. Okay, not an allowance. Here it's a prerequisite. Allowances, as I mentioned, is something like probably house rent allowances. You move to a different city and you have to pay a certain amount of money to your landlord. That amount is refunded by your employer. That's an allowance, house rent allowances. A lot of times you also get DAs. A lot of times you also get city compensatory allowances, which we will talk about right now in Karamchari Union versus Union of India. So the major question in Karamchari Union was whether all these allowances like HRA, DA, city compensatory allowances, are they a part of the salaried income or are they an additional benefit that should not be taxable? Okay, this was the major question issue. Okay, has anybody read the case? And does anybody want to talk about the facts of Karamchari Union? What exactly happened and what led to the filing of the case? Anybody? What happened in the Karamchari Union? I just want to know the facts of the case. Okay, all right. There were actually several suits on to understand what prerequisites allowances actually meant across India in the period, I think 2000 or early 2000, something like that. I don't exactly remember the year. You can later on go through the case. It's on your LMS. So yes, and about the cases, definitely go through the whole judgment. You can also go through the reading material, but the reading material part is concised. It's given to you. We actually only put down the specific paragraphs that are important in the reading material. But for your benefit, I would always say go through the whole case in itself. So yes, the facts. So there were several similar issues that came up about prerequisites, about allowances across the country. Okay, and most of these petitions were filed by um, army based workshops. The army based workshop was generally by Karamchari Union. They were the ones who filed the petition. There were petitions filed by bank employees, PSU employees, central government employees, and most of the employees received various types of allowances, which here include the city compensatory allowances. Okay, so first, the Allahabad High Court, sorry, not Hyderabad, Allahabad High Court. What they said about the city compensatory allowances is that they ruled that any type of CCA, city compensatory, any type of DLS allowances, house rent allowances were not only reimbursements of the employee's amount by the employer, but it was an additional benefit. Okay, and since it was an additional benefit to their salaries, an addition to their salaries, it had to be taxed. This is what Allahabad High Court had stated. However, the in a very similar circumstance, another case that was filed in the Calcutta High Court, the Calcutta High Court stated that any type of city compensatory allowances, since you're moving cities and you are and the employee is paying a certain amount of extra money, any type of extra money to relocate, to get a new house, to pay for new things, it is a reimbursement from the employer's side. It's just a reimbursement. So you pay 10,000, you're getting your 10,000 back. So it cannot be charged to income tax. Okay. So now, since all these courts were differing in their decisions, some they were saying no, these are taxable, the others were saying no, these are not taxable, they are just reimbursements. The question came to the Supreme Court. The Supreme Court of India had to now decide on whether such allowances were a part of the salary and thus whether they were taxable or not. Now, to get to this taxability, whether they were taxable or not, the Supreme Court broke down their judgment into three major parts. Okay. So, in order to understand, just listen to me so that you understand how they broke down, and then you can go through the judgment in itself and understand what the Supreme Court has said. The Supreme Court broke down the judgment into three parts, sorry. The first was looking at the definition of Section 17, looking at the definition of income within Section 2, subclause 24, as we had discussed in the earlier, in the first 10 minutes of our class. Section 224, what income actually includes. There, we had seen that Section 224 had mentioned the parts of allowances, prerequisites, a lot of times, right? So now we'll discuss that. Secondly, whether they come within the definition of salary under Section 17 or not. Okay. And lastly, interpreting the words profits in lieu of salaries. Okay. These were the three major parts that the Supreme Court had looked into. Section 2, subclause 24, what it said and whether it came under such allowances. Second, whether such allowances actually was a part of salary within the definition of Section 17. And third, whether what was the interpretation of the words profits in lieu of salary. Okay, first, as I stated, defining the word income within Section 2, subclause 24. Now, if you look at Section 2, subclause 24, 3A as well as 3B, nothing in that mentions that such allowances are not covered within the definition of income. Moreover, it is an inclusive definition that specifically states that any allowances here, as I stated earlier, I've been stating, is a benefit or something in addition to your salary. So any allowances, benefit specifically granted to the assessee exclusively within the purview of your course of employment or within the privity of the contract that you hold with your employer. Okay. Any type of addition on top of this privity of contract with your employer, will be considered as allowances. First. Second, what the definition stated under Section 2, subclause 24 is that allowances for any personal expenses or increased cost of living. Increased cost of living is mostly dearness allowances. That is it. So it takes account or it takes hold of any type of other expenses that your employee is going through. And these employers are also granted to the assessee. Assessee here is personal expenses for relocating or for education. A lot of employers also give you that benefit that your children education, some amount are paid by them. All this within the definition or within the course of employment is given to you, then it will be considered as to be allowances, special allowances, benefit, or prerequisites. Okay, and thus would come under the definition of income. That's what the Supreme Court looked into first. So nothing in Section 224 actually excluded your allowances from not being a part of the income. Secondly, when we look at Section 17, we see the word profits in lieu of salary. Now the problem is, okay, allowances, benefits. This has been mentioned across all sections. But what does the word profits in lieu of salary mean? Does it mean that your employers, you are getting a part of the profits of your employers? So, for example, you are part of, say, Reliance, and Reliance makes a certain amount of profit. And as an employee of Reliance, you get a part of that profit. Is it just that, or does it mean more? This was the question in front of the Supreme Court. So, what the Supreme Court understood from the word profits is that they first looked at the basic definition of profits, what profits meant. What profits actually meant is that it is an advantage or a gain by the receipt of anything from your employer. Anything from your employer, not just that your employer has gained a certain amount or your employer has profited a certain amount and you're getting profits from it. Not just that, but could be anything that your employer gives you, right? Secondly, when you consider, when you look at section 17, it is exhaustive, it is inclusive as well, and the words profit is required to be understood as the gain or advantage that the assessee is receiving from your employer. This does not necessarily mean that they are receiving only a certain amount of profits from the business, but it could mean any type of gain that they are receiving. Okay, so here the word profits in lieu of salary includes any payment. This payment would be understood as a gain or advantage, very similar to profits received by the assessee, even if that payment has no relations with the profit of the business or profits of the employer. So, thus, what we can say is any type of pecuniary gain received by the employee in the course of his employment in the terms of payment of money in relation to the additional part of the salary, addition to your salary, such allowances would be considered under section 17 a part of salary within the definition of in profits in lieu of salary, and thus would be chargeable to income tax. It would be considered as income within the definition of salary and chargeable to income tax. All right. So this is what Karamchari Union actually stated. Very basic that whatever your one second, I have a question. Okay, all right, no questions. So whatever your allowances you're getting on top of your salary, that would not only be considered as to be a part of income within the definition of section 2 subclause 24 3a and b, it would also come within the definition of profits in lieu of salary as to be an advantage or any type of payment that you're getting. This would be considered as to be an addition to your salary and thus chargeable to income tax. Okay, this is what the Karamchari Union case had defined or stated, what the Supreme Court stated. Okay, now, does anybody have a question on this particular case? Any questions? Allowances is income, Vivek. Allowances will be considered as income. This is what I was stating so long. Is the Supreme Court under section 2 subclause 24 looks at allowances. The section does not necessarily does not exclude this type of allowances. They are inclusive of these allowances. They state that yes, these allowances, prerequisites, are a part of the income. Along with it being a part of the income, can allowances be also considered as profits in lieu of salary within the definition of section 17? Yes, they can be. Why? Because profits is type of gain and advantage, and these type of allowances is also a gain or an advantage on top of your salary. Since it's a gain or an advantage on top of your salary, it will be considered as an income. And since it is an income, it will be chargeable to taxes. All right. It is a part of your income. Any other questions? All these allowances that I've been talking about, the city compensatory allowances, dearness allowance, house rent allowance, any type of educational benefit that you are receiving, educational benefit has a certain threshold. If your employer is paying more than that threshold, then it will be taxable. Okay, only for educational. But for other allowances, like I mentioned, the city compensatory, house rent allowances, all these are taxable because it's an addition to what you are getting. Since an addition to what you're getting, it's not only allowances, it will be considered as allowances within the definition. But the Supreme Court also looked at the definition of profits and due salary within within section 17 in order to understand, can this be also put into purview of profits and due salary? Yes, it can, because it's a gain or an advantage, right? Okay. It's 9:53. We will take a 10-minute break and come back at 10:03. Okay. And within that, if somebody has any questions till whatever we have done till now, please note that, and I'll come back and we'll discuss the questions, and then we'll go forward with another case of ITC Limited. So we'll do that right after this. Okay. Okay. Yes. Let's get back to what we were doing. But before that, um, does anybody have any questions till what we have done? The sections, the case that we just did, whatever. Just please let me know. I'll just give it a minute if there are any questions. Else we will move forward with the ITC case. Okay, I will assume that there are no questions right now. But if you do have, please leave it on the chat box. If you have questions on the next case as well, we will do that at the end of the case. So yeah, so till now we were discussing on allowances as to be whether they are a part of the income, and it is a part of the income, it will be taxable. Now we will look at a very different type of could be an income, could be anything else, but it's an income as well. So what happens to tips that waiters or any type of hotel management employees, any type of employees in a hotel gets? So what happens to these tips? Are they considered as to be part of the income, or are they considered as to be part of the salary? What is happening in this situation? This situation would be detailed upon in a case called ITC Limited versus CIT. This is a Delhi High Court case, and it is on a few hotels, but majorly on ITC Limited. So here the assessees are ITC Limited, and there's one other hotel. So what happens is it is found by the tax department that 1 second. Yes, it's found by the tax department that these assessees were was paying tips to their employees, were paying tips to their people who are working in their hotels. But on top of the tips, they were not cutting TDS, or they were not paying taxes on the tips that they were giving to the employees. So the assessing officer treated these payments of tips, a part of the salary of the employees itself, the assessing officer, as in the revenue department. And so it was stated that the assessee was liable to pay TDS on this, and that it is liable to be deducted as part of TDS. So obviously the assessee here, the ITC, they went up to the court and they filed and appealed to the Delhi High Court. After the tribunal, it went to the Delhi High Court. The Delhi High Court had two specific cases, two specific issues in front of them. The first issue was whether such tips would be a part of income and thus would lead to being constituted as salaries, or secondly, whether the assessees were actually liable to deduct taxes or TDS. Okay, so any employee, so in order to understand the TDS part, you just have to look to section 16, which I had dealt with in my previous, in the first hour. Okay, so TDS is nothing but a part of the income that is deducted at source by the employer. So only if you have a contract with your employer will the TDS be deducted, right? So the question were these two basic questions, right? Whether tips were a part of the salary or not. This is the first question that we will deal with right now. Now, what is your first thought? Do you think since tips are not necessarily allowances, prerequisites, then what can tips be considered as? Can it be considered as a part of salary? What do you feel could be a perspective that the revenue or the assessee can take. Anything can be. Your views can be towards revenue, your views can be towards assessee. What do you think? Anyone? Even if you have not read the case, if you have heard me in the first hour, maybe you will have certain amount of opinion as to what can this be.
Ma'am, if there is a contract between the assessee and the person who is getting the tip, if it is mentioned tip will be given on this basis, then it will become a taxable this thing.
Okay, all
If
right.
it is not mentioned in the contract, then it doesn't fall within the purview of the income this thing, so it's exempt.
Only if it's mentioned in the contract of their
Yes,
employment.
yes.
Okay. Anybody else? Okay. What if I ask you that tips are not mentioned as a part of their contract? Nothing is written on their contract about tips. Then can it be considered as to be a taxable income? Because then a person can earn a lot of money only through tips, and then technically the revenue department should charge a certain amount of tax on the tips that certain people do get.
Yes.
Okay.
Because it's arising from the same source of that business which they are in, the hotel.
Sorry, I did not understand.
It might be considered as business income.
Business income.
Ma'am, as per my opinion, it is income from other sources.
Okay. Anybody else? Okay. Dutt has written, arguably tips are compensation for a good service and a gratuity, and the definition of income is so wide under section 2 subclause 24 that it would include tips.
Ma'am,
Okay.
when tips are paid by the customer, it doesn't become taxable. When paid by the employer, it becomes taxable.
When paid by the employer, it becomes
As a part of the.
yes. Actually, it is right in certain ways that if it is paid by the employer, then it is taxable. And what Dutt has stated about tips are compensation for a good service and a gratuity, right? It is a tip for your good service. It mostly comes from the customers. It's not from the employer themselves. And that is what actually the assessee had argued, that tips are not a part of what we are giving, but it is what the employees are getting for their good service from the customers. However, what the income tax had seen is that these tips were actually held by the employer. They actually took the tips to whatever employee was it was liable to, and later on they had given them the tips back. So necessarily they had taken the tips and they had given the tips later on back to the employees. So essentially what happened in this case is, yes, tips are a part of your income. It will be a part of your income. It will be taxable. But how? That question arose majorly. So when we look at tips, the first argument by the assessee was, look, um, within the contract of the employment, we have not mentioned that tips are what we are going to give them. Tips are something that they are going to get out of the contract of employment if they have done some good work for our customers. The customers, as a part of a gratuity, as a part of appreciation, would can give them a certain amount of money. That's something totally on them. It does not arise from your contract of employment. Firstly, this was the argument of the assessee. Taken together, it is a right argument that it does not arise from the contract of employment and thus cannot be considered as to be a part of the salary, but an additional income that the employee is getting from the customers. The revenue, on the other hand, had picked up the part where they stated that, okay, even if you're saying that tips are not a part of the salary, not a part of their income that they are receiving from the hotel. However, the hotel is holding as a fiduciary the amount or tips that they are receiving from the customers and then later on paying the employees who they are liable to pay. Okay. So essentially, indirectly, you are holding the tips and later on giving them to your employees, even though not directly related to the contract or privity of contract of the employment. Now, would that be considered as income from other sources? Not really. Why? Now let's look at what we had interpreted in our previous. Now this case also relied heavily on Karamchari Union, which is the previous case that we discussed. And so we'll look at section 17, profits in lieu of salary. Again, now obviously, as I mentioned, that the employer is not giving you the tips, it's a gratuity payment that you are receiving. Therefore, tips are not salary in lieu thereof, right? However, the High Court of Delhi pointed out something in section 17, subclause 1, subclause 4. If you go through it, it's written profit in addition to salary. Not in lieu of salary, but in addition to your salary. Thus meaning and expanding the term salary by including anything received by employee in addition to their salary or wages. So anything that they received in addition to it, right? Secondly, when we look through the payment part, right? The court also addressed the phrase of profits in lieu, very similar to the cases in Karamchari Union, where they had stated that any payment due to or received from an employer, even if it's not in connection with the employment contract, but since it accrued because the employment contract was there with the hotel, thus it could be considered as to be profits in addition to their salary. So for example, even if it did not mention that tips were a part of their contract, since by the virtue of them having the contract with the hotel, with working with the hotel, only if they had the contract, then only they were liable to get tips from customers that entailed that it was a part of their salaries, right? This was kind of mentioned by, I think, Henry. He kind of got there, but kind of disrupted himself later on, but that's all right. But he still was there. And so what we here at the end see in this case is that firstly, it's not necessarily a part of the salary, but a certain profit in addition to your salary or wages, not allowances, not prerequisites, not profits in lieu, but a profit in addition to your salary. Now, why is it happening? Because whatever the contract they had, even though it did not mention that tips were a part of their salary, they ended up getting tips because they were in contract or in working terms with this hotel. Then only they were getting a certain amount of payment from the customers that ended up being a part of their salary and thus taxable income in the hands of the assessee. Now, since the assessee was paying this whole amount to its employee, so it entirely depended on the legal nexus between the tips that were received and the course of employment or the contract of employment that was happening. We're looking at assessee's point of view now, the hotels, whether the hotel was liable to pay TDS or not. So it depended on whether they had a course of employment or a contract and whether there was a legal nexus between the tips and this contract, which was there. What the court has stated that the obligation for an employer to deduct TDS was entirely dependent on whether the person paying the income was chargeable under the head of salaries, right? if they were chargeable to income from the head of salaries, then the employee was liable to pay TDS under section 16. Now we have kind of deduced it out that yes, tips that you're getting is a part of the salary and can come within the definition of in addition to salary or wages, right? So with the above argument, with this argument, it was also seen by the High Court that the employer, by virtue of their employment, allowed the employee to receive tips from the customers. Thus, this course of employment that allowed them to take advantage of the payments fell within the ambit of Section 17. And thus, through the virtue of this employer-employee relationship, the salary, the tips that they were getting was a part of their salaries and thus was taxable as a part of their income. All right. So this is what exactly happened in ITC, right? Does anybody have any questions on it? Is there any part that you have not understood? Any part? I'll give it a minute so that you guys can clear your thoughts and let me know if you have any questions, please. The definition of section 2 subclause 24 is broad enough to cover a lot of types of income, allowances, profits in lieu, prerequisites, whatever. But we will look at section 17 more deeply in this case. So more reliance was given to section 17 in this case, and a little than Karamchari Union. 17 because you had to understand whether it fell under salaries or not just income, but within the purview, because it's very clear in this case that it is salary, it is income, because you are getting some additional amount. So it will come under the purview of section 2 subclause 24. Whether allowances, prerequisites, that's a later question, but it does come under the purview of income. However, does it come within the definition of salaries? Why were salaries important to be taken within this definition is that in the end, would these hotels be liable to pay TDS on the tips that their employees were realizing, right? Yes, they would, because this is a part of their salaries. And thus, if it's a part of the salaries, they would have to pay TDS. Okay. Any more questions on this? Okay. Okay. I have one question for you. So these are the majorly two the sections and majorly two cases that that are about salaries. Okay. Now, in the very recent times, we have come up with very different types of way of paying employees. A lot of them are, as I mentioned, ESOPs, which is taxable. ESOPs are taxable, not when you get them. So, for example, I'm an employee of NLS. NLS decides to give me, NLS does not have stocks or shares, it's not a company. But for example, NLS is a company. Then NLS decides to give me a certain amount of their shares or the stocks when I'm joining them. It won't be taxable at that moment. However, if I sell off the amount, sell off the shares on a later date, when I sell off these shares, it will be considered as to be a capital gain. Okay. All right. Outside the, so in your reading material, the case that has been given is your tribunal's case. That is your ITR, the Income Tax Tribunal's case. But the case that I have discussed right now is your High Court case, right? So your High Court case has been mentioned in your session plan under, if you go to your session plan, you'll see ITC versus CIT, right? You go to the link, click it, and then you'll find the whole judgment. That is your High Court of Delhi judgment. The judgment that is given in your reading material is your tribunal judgment. That's why I told you in the beginning that the tribunal case went up to appeal the Delhi High Court. All right. The Delhi High Court stated whatever I have given you, whatever I've talked about right now. So just be aware of this, that the case that I talked about right now is your Delhi High Court case, the appeal that went out from the tribunal. The tribunal case is your ones that we have mentioned in your reading material. If you want to go through the ITC case, please go through the link that has been provided on your session plan. All right. Okay. Sorry, I was saying yes. So ESOPs is one of them. ESOPs is where only when you sell off your shares to the market again will your income be realized, and then it will be considered within the purview of capital gains, right? A lot of times I've also heard some of my engineering friends get something called a joining bonus. So they have not joined it just because they have signed a contract with a new company. They end up getting a considerable amount as a joining bonus. Can we consider joining bonus as to be a part of Section 17, as a part of salaries? And can it end up being taxable? Anybody?
I'm so sorry. Could you just repeat the last part of the question once, if you don't mind?
Yeah, sure. So, example of joining bonus. A lot of people get joining bonus when they start off at a new company. And when they do get the joining bonus, it's their contract of employment has not necessarily started, but they just get it as an appreciation to come and join a particular company. Would that joining bonus be considered as within the definition of Section 17, that is salaries? Would it be salaries? And if so, would it be taxable?
In my opinion, yes, I think so. It will come within the purview of salaries because number one, a joining bonus is not necessarily an appreciation for you to come and join the company. It's basically a monetary consideration that's paid to an employee, which basically signifies or rather consolidates his intent to come and join the company. So the thing is that if I am going to join a company and I've got a joining bonus in lieu of it, I'm expected to join the company. So it seals the contract between the employer and the employee. So that payment can come within the purview of an employer-employee relationship, and hence it can be taxed. So it's not necessary that the employment contract has to begin, but the thing is that since I've already accepted a consideration from the employer for joining that particular company, it can be it can qualify as a salary, in my opinion.
So, considered as a salary.
Yeah, it can be taxed as a salary.
Okay, but don't you think that it's not necessarily an allowance prerequisite? What could it be for? I understand whatever you're saying is right, but how would you kind of put it into a legal framework of, okay, it's not allowance, it's not prerequisites. What could it be?
Well, I would say that I would say it's a perquisite. I would say it's a perk. You can classify it as a perk because it's basically an incentive that's given by the company to you to join the company. I
Yes,
mean, like it can't be considered a regular monthly pay like a salary that we
right.
draw. But the thing is that it won't come as an allowance because it's not for meeting any personal expenses. A relocation allowance, which may be given by the company in order for you to relocate to another city, may be considered as an allowance because ultimately the company is paying for you to relocate to another city. But a joining bonus per se will be considered a perk. It can be classified as any bonus that you get even after you join employment. It's basically like a perk that you're getting from the company. So it can be classified as a perquisite.
Okay. Yes, Nitin is right. Nitin, whatever Nitin has stated is very accurate. whatever joining bonus you're getting is an a kind of an addition to the fact that you are sealing your contract with a certain company, and that ends for you to getting a bonus. Now, whether the bonus is a prerequisite is a different issue altogether. It is a perk, right? It is a prerequisite. Good. But since section 17, if you look at it, it does mention the word bonus within the definition of salary. So in itself, if you just look at the section, bang on, you will see the word bonus and it would come under bonus. So it does not necessarily, you'll have to look at it. It's not allowances at all, because it's not something that you're getting in addition to your salary. You're getting it much before than you have joined the company. So it's not a salary, like basic salary. It won't be taken as an allowances, but it would be taken like a bonus and a commission that the company is paying to you for coming to join their company. Right. So I guess we have understood what salaries, what bonuses, what allowances, prerequisites are. Um, and I am hoping that you have understood the concept of salary right now. Now, if you have any questions on anything on whatever I've done today, let me know. Or else I'll just sum up and then we'll move on to the Raj the Darkar case and start with the business income part. If anybody has any questions on anything.
I just have a question. It's
Yes.
might be a little offbeat actually. So it's with respect to tips. So as tips is basically is since tips are basically paid by the customers directly to the waiters or to the staff at the restaurants, and it's not necessary that a hotel or a restaurant has to collect tips on behalf of the staff from the customer. In that case, how can it qualify as how can it be part of salary, especially since that the person who's paying a tip is not my employer? There is no employer-employee relationship between the customer and the waiter, let's say in this case. How can it still be
Right.
qualified as salary?
Yes. So take it as, first take the contract. Okay. When you are in a contract of employment with a hotel, even though it does not mention tips. Okay. Secondly, let's state that the employer is also not holding these tips as a fiduciary duty. Both of it is not there. However, by the virtue of the course of the employment, in the course of the employment, in the virtue of the contract that you hold with the hotel, you are getting or receiving the money. If you were not an employee of the hotel, you would not have received any types of tips. So this is something that you are getting by the virtue of holding that privity of contract with the hotel itself. It does not necessarily have to mention that tips is a part of your salary or tips is a clause within your contract. They do not also have to hold a fiduciary duty to hold the money for some time and then give it to the employees. No, but the fact that you are working within the ambit of this hotel's responsibility, obligation, and through those duties that you are playing within the hotel, you are getting tips, is the fact that this would be considered as salary, and that a part of a taxable income towards the workers. Um,
Yeah, that clarified it. Thank you so much.
yes. Okay. Anything else? Anybody? Okay. So I'll just run through what we have done today within the next 10 minutes, and then we'll go to the business income part. I'll just start off with the business income part today. So what we started off with section 2 subclause 24, which essentially talks about income and what income includes, right? 1 second. I think I have a question. Section 224, what income includes. Within section 2 subclause 24, wait, I'll just share my screen here, which would be easier for you to grasp. Wait, just give me 1 second. My PPT is not opening up for some reason. Yeah. Okay, can you all see the screen? Can you all see the PPT at least? Okay, anyway, so I'll just move on. Yeah. So subclause 2, 24, 3A and 3B, if you look at it, it gives you an overview of what exactly is your income, what exactly income includes, and everything related to allowances, prerequisites, what would be considered within allowances, prerequisites, personal expenses, and increased cost of living. All these give you an ambit as to what, apart from salaries, are included within the definition of salaries and what is in addition to salaries, right? Section 15 shows us the due versus receipt. So due is any amount which is not paid yet, but you will be paid at a future event. You will still have to pay income tax on it because you have realized that income, right? Secondly, received is any income that you have been credited to your account, so you've received it. Apart from this, we have section 17, which has an inclusive definition, a very exhaustive definition of whatever is included within the definition of salaries. Please go through the definition of section 17, definition of salary. It is also the charging section. So it does not only include wages, allowances, annuity, pension, all of these, but it also goes on to mention bonuses, profits in lieu of salary. Profits in lieu of salary is what we discussed in Karamchari Union case, and how different types of these allowances like HRA, DA, CCA, how these fall within the ambit of profits in lieu of salary. How? Because profits, if we consider the term profits, it is a type of gain or advantage. If it's a gain or advantage that you are being paid on top of your salaries, then it would definitely come as a part of your salaries within the definition section 17, and thus end up being within the purview of salaries and a taxable income, right? So here I have given you a kind of a very short way of putting this case. Next is ITC versus CIT that we did. Okay, here the major question was whether tips received by the employees of a hotel could be taxable as salaries. So in order to come to that, we have to discuss whether it falls under the definition of salary, whether it falls under definition of profits in lieu. And what I have stated is that it does come under the view of profits in lieu, but it also comes under the purview of subsection 17, subclause 1, subclause, I think 2 or 3, something like that, called profits in addition to your salary, right? You are getting it from the virtue of the course of your employment, not just your contract. Even if you're, just as I mentioned to Nitin, is that it does not necessarily have to be a clause stated within your contract. It does not have to be that the employer is holding a fiduciary duty or holding the amount as a fiduciary. But the fact that you are working in that hotel makes you liable, or whatever duties you're doing, you are liable to get paid. That is a part of your rights to get paid tips. Now, if it's your rights to get paid tips, it's within the virtue of that contract that you hold with the hotel. And since it's coming from that, it is considered as to be a part of your salary and thus taxable. The hotels have to pay TDS on even the tips that they receive from tips that these employees receive. Okay. I've mentioned that. And lastly, we'll do the Raj Dadarkar case. Okay. Now, I will post this particular PPT on your forum. I will also, I think we don't have the rest of the PPTs also that Sir had been talking through. I will also post them if it's possible within the next 1 or 2 weeks. And we will send it to Pace, and then we will post it on the forum. Okay. Okay. Now we'll do the last case, which is the Raj Dadarkar case. It's about business income, how we will classify business income, what exactly entails within the definition of business income. Now, Sir will do more in details what business income means, because he'll go through each of the other cases, which is much more important than Raj Dadarkar. But Raj Dadarkar is just a way of giving you the ambit of something called the dominant test, the dominant test or the objective test for business income. What it is and why it is necessary, I will just start with. Okay. Now, what happened in the Raj Dadarkar case? Very simple. There was a certain market area within Mumbai city, and this market area was supposed to be rented out. It was auctioned, and the rights of the marketplace was gained by Raj Dadarkar and his associates. So basically, he was renting that whole market area. Now in that auction, Raj Dadarkar and associates, they gained possession of the market portion. The terms of the auction resulted in Raj Dadarkar getting to build the premise of the market area. They were the ones who were actually building the market area. And what happened was, they established the shops, the stalls, everything within the market area, and later on only got a certain amount of rent from these shops and stalls. So whatever was happening is that they subleased the shops to other people, and whatever the amount that they were getting from leasing this was their income. This is what is happening now. There, each type of business has a certain amount of object that they work under. For example, today I work for a legal firm, a law firm. The law firm's objective is to resolute or mediate certain cases, go to high court, litigate, whatever. This is their business income. This is what income they are getting from doing their business in probably a court, probably just mediating or arbitrating, whatever. However, they also have other properties that they are leasing out or renting. Now, that renting of apartment will not be considered as to be their business income. The business income is only what their objective of the firm is. The objective of the firm is to litigate, to help people mediate their cases. This is what is happening by a law firm. So that is their business income. The amount or profits that they are getting from renting out a certain place or asset, that is could be considered as to be income from house property or income from rental income, right? They're just rental income, nothing else. Similarly, what happened here is that the object of the firm was to kind of hold businesses on these premises, So the revenue department, what they stated was that, okay, whatever you're doing here is not a part of your objective of the firm, but you are just getting rental income. And thus, whatever you are gaining from this premise will not be considered as a business income. It will be considered as to be income from house property. Now, the revenue department also considered that Raj Dadarkar and associates were actually deemed owners of this particular premise. that they were holding, the market premise, deemed owner. Now, what is deemed ownership? If you look at section 27(3)(b), that is what deemed ownership will give you a kind of a overview of what deemed ownership is. So it states that when a person acquires the rights of a certain area, portion, or land or building over a certain, I think, I'm forgetting the amount of years. You can just have a look at the section and get to it. But if they are holding a certain amount of lease rights or rental rights to that area for over that certain years, then they will be considered as to be deemed owner of that premise. Not only that, the nature of the transaction that Raj Dadarkar had gone into was considered as to be a transfer of immovable property, which resulted from the virtue of, I think, section 269 UA of the Income Tax Act, and the leaseholder rights that Raj Dadarkar held was more than 12 years. So, through the virtue of section 27 as well as 269, what ended up happening here is that Raj Dadarkar became a deemed owner of this premise. And since they became deemed owner of this premise, they were also considered that, okay, right now you are not doing any type of business, because firstly, your objective is to kind of modify the place, take into account maintenance, make sure that everybody within the premise are getting access to facilities. You are not doing that. Whatever you're doing is just getting a certain amount of rent from renting out the places that you have made. Okay, so they are primarily just renting out the places, nothing else is happening here. Okay, so since they were just renting out the places, the dominant test here is what your objective of the firm is. The objective of the firm is not just renting out shops, but you also have to take care of the maintenance premises and other facilities of the market portion, which the associate or the company was not doing according to the revenue department. The revenue department stated that they had failed the dominant test. They did not, the objective of the firm here did not comply with what they are doing. What they are doing is, what the ITAT found out was that they were just holding or holding the position of the market, right? And the appellant had not established any type of engagement in any systematic organized activity around the market area. So what they deemed is that their activity cannot be inseparable from basic charges of rent. It was just basic charges of rent. Since it was basic charges of rent, it would only come under income from house property and not business income. So, concluding from this particular case, your first test of whether it comes to be a business income or not should be that what is the objective of the firm or the company or the business? Are they doing what the business has objectified in their statements? If the income directly comes from this type of business, for example, a business is just, I mentioned that you are a law firm and whatever you are realizing as an income is from litigating or mediating, then that is the only part that would be considered as a business income. That is the objective of the firm. If you are just renting out certain areas, then it will not be considered as to be the objective of a law firm. It will not be considered as to be a business income, right? So this is what is the dominant test or the objective test for that had come up from the Raj Datarkar case. In the next few sessions, you will go through the different types of business income. Now, business income, I think you'll go through the Sundar Iyengar case and the Logitronics case and all these cases to ascertain as to what exactly is business income. But for now, this is a basic test that you have to see whether a company is earning business income, or it's earning income from other sources, or from other rental income, or from shares, dividends, or capital gains. Okay, so have you understood this case or not? If anybody has any questions, please, I'll give it a minute so that you can question any, pick up any questions you want. Any questions, guys? Okay, I think I have a question. 1 second, just. Okay. What's the rate of tax higher on income from house property versus business income? As far as I remember, I think the rate of house property income is higher. I have to check. 1 second. Just give me 1 second. I want to check it. Yeah, business income actually has a lot of exemptions. So the rate of interest will vary, but there is a lot of types of different exemptions under section 1 second. Sections 37, I think 30, 37, 36, all these have different types of exemptions that you have within the definition, or if you are a business and you are incurring business income. And for rental income, I think there is no there is a flat standard deduction, but there is no exemption on top of that. Okay, so if you are paying rental income, it would be a little more higher than business income, since you will be getting a lot of types of different exemptions for business income. Any other questions? Any other questions that you have? Could be on salaries, could be on this particular case. um okay, since there are no questions, this is the session for today. We have given you an overview of sections 15, 16, 17, and we have done two very important cases, Karamchari Union and ITC. Both of these cases, I would recommend go through the whole judgment, have a look at what the courts are interpreting, what each doctrine states, sorry, doctrine not, the judgment states, and what each court has come up with their decision. Apart from this, just have a look at the different business income side or concepts of business income for the next session. Next session will be taken by Professor Nigam himself, and I will later on take income from other sources and one other session on tax avoidance and international taxation. So yes. All right. Thank you so much. Have a nice day.